A judge just said that the Second Amendment does not apply to firearms without or with an obliterated serial number. And thus, this judge finds them dangerous and unusual because he thinks he's Congress, and has gone against a decision in October related to Bruin. I want to tell you all about this because it's going to be confusing for some. And I want to thank the sponsor of the video, and that's the Sonoran Desert Institute. Guys and gals, SDI has a ton of classes that you can educate yourself with. You can become a better individual or even take classes and get a degree in the firearms fields. From ballistics to gunsmithing and everything in between, SDI has a ton of options for you. Check them out, sdi.edu/GNG. They're fully accredited. They have financial aid. It's legit, and all of the tools and materials you'll need will be shipped directly to your door because it's a distance learning institute, which makes it even easier. You can do it on your own time. Guys and gals, check them out, sdi.edu/GNG. Thanks to SDI for being a friend. I miss you guys. Can't wait to see you all again. All right, guys and gals, let's talk about this case here. Of course, this is in Colorado, where this is obviously, when I read this decision, this is obviously to me an activist judge who hates guns. And the judge did everything he could to circumvent Bruin to get to the ends means. You know, the old ends means scrutiny that Bruin said don't do. He just did it. I'm going to show you a couple clips of the actual text. If you want the whole decision, I'll have it pinned down below. But just know this originates from a criminal case. So this cat was booked and convicted of 2 counts of distribution of fentanyl, 1 count of distribution of cocaine, and 1 count of possession of a firearm with an obliterated serial number. And the last time we talked about this was in October. The video's floating above, when the judge in that case said that there was no text, history, and tradition of serial number requirements. That didn't come up until the Gun Control Act in the 60s. So the judge said that 922K, what it's known as, is unconstitutional. Before we continue, let's tell you what 922K is and what it actually says. 18 U.S.C. 922K provides, it shall be unlawful for any person knowingly to transport, ship, or receive in interstate or foreign commerce any firearm that has had the importer's or manufacturer's serial number removed, obliterated, or altered, or to possess or receive any firearm which has had the importer's or manufacturer's serial number removed, obliterated, or altered, and has at any time been shipped or transported in interstate or foreign commerce. Let's go to the analysis here. It says, in the construed motion, the defendant relies heavily on a decision from the Southern District of West Virginia, that's the case I talked about, U.S. v. Price. He argues that Section 922K is facially unconstitutional in light of Bruin because bearing arms is a constitutional right that is not subject to means and scrutiny and does not account for any governmental interest in punishing the bearer of a firearm with an altered, obliterated, or removed serial number. Moreover, because serial numbers were not broadly required for all firearms manufactured and imported in the United States until the passage of the Gun Control Act of 1968, the defendant argues that Section 922K is inconsistent with this country's history and tradition of gun regulation at the time of the founding. Beyond pointing to Price, the defendant does little in the construed motion to analyze the impact of Bruin on the constitutionality of 922K. The government argues these laws are relevantly similar to 922K because they address similar goals. 1, controlling and tracing the sale of firearms, and 2, ensuring dangerous individuals did not obtain firearms. The Gun Control Act of 1968, which included Section 922K, was enacted to keep firearms away from persons Congress classified as potentially irresponsible and dangerous. Therefore, the government argues that Section 922K is consistent with this country's history of firearm regulation and is therefore constitutional. There's one big problem with that argument, though. Passing laws does not nullify the Constitution. So you can write whatever law you want, but if it's in violation of that document, the law is null and void. And they just said it in black and white. Let's talk about the court saying that 922K does not implicate the Second Amendment. The court has carefully read Bruin and is sensitive to its admonition that lower courts apply a one-step test. Nonetheless, the opinion's logic is difficult to collapse into just one step. In the court's view, Bruin's directive is best understood as one to eschew means and analysis in favor of text, history, and tradition. In Bruin, the court's textual analysis proceeds by answering whether 1. Petitioners are part of the people whom the Second Amendment protects, 2. The arms at issue are weapons in common use today for self-defense, and 3. The plain text of the Second Amendment protects the petitioner's conduct. The first two of these questions were not in dispute, so the court focused on the third. Arms, as used in the Second Amendment, is limited to those in common use at the time. Accordingly, the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. On the contrary, prohibition of dangerous and unusual weapons is well established as part of the historical tradition of this country. On the record before it, the court concludes that firearms with obliterated serial numbers are not within the class of firearms typically possessed by law-abiding citizens for lawful purposes. The court also finds that firearms with an obliterated serial number, like the one defendant is accused of possessing, are dangerous and unusual weapons and therefore not within the scope of the Second Amendment's guarantee. In sum, the court holds that the kinds of firearms 922K prohibits are not arms within the meaning of the Second Amendment, and as a consequence, the defendant's constitutional challenge to the statutory provision fails. Now let's talk about the history and tradition. It says, because the court finds that Section 922K does not impact arms covered by the Second Amendment, it need not take up the separate issue of whether it is in the accord of this country's history and tradition of regulating firearms. So this judge is saying on one hand, we have a well-established history and tradition of stopping people from carrying dangerous and unusual stuff, but because it'll destroy my argument, we're not going to go forward and try to find actual laws from the founding era of history and tradition that would say that I'm correct. Sorry, Judge, you can't have it both ways. Let's continue. For the reasons set forth above, the construed motion is denied. Dated on the 8th of May, 2023 by Judge William J. Martinez, who is the senior U.S. District Judge for the District of Colorado. And just like that, went totally against what another judge said in West Virginia. So now again, we have two circuits in disagreement. So I don't know if this case has been appealed yet. I would suspect it would be appealed because we have another case that says serial numbers weren't required during the founding era, not part of the text, history, and tradition. So 922K is unconstitutional. Now this guy is sitting in jail because of 922K. Maybe not a great stand-up person because he was caught dealing fentanyl, which is one of the biggest killers in this country, right? But does he deserve to get charged and add time to him for something that another court said is unconstitutional? And that's what's at stake here in this case. And I want you to weigh in. What do you think? Do you think serial numbers are needed? Do you think there's a value to serial numbers? I personally don't. It's just a way for a backdoor registry, and this government's proven time and time again that they can't be trusted because they're always doing something behind the scenes that they shouldn't. Funny how that works. But let me know what you guys and gals think down below. I wanted to bring this to you so you could be aware. We now have split decisions in different circuits about 922K and the serial number requirement. Guys and gals, I appreciate every single one of you. If you want Second Amendment news every day, then subscribe to this channel. I will always bring you the truth, the plain truth, and nothing but the truth. So help me God. And I appreciate each and every single one of you for sticking around. Till we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. We'll see you all in the next one. Take care.